I'd like to call the Joint Board of Elections meeting to order. Today is April 19, 2013. It's 10:35. First, I'd like us to take a few minutes, if any way that you want to say a prayer, because it was really hard coming from St. John this morning and Dockin, and I heard it was the same way for the persons flying from St. Croix. I'm glad you came with no mishap, because this whole week we've had many mishaps. So let's take a few minutes, please. Thank you very much. Everyone has a copy of the agenda. We have extra copies. And following our agenda, we'll have yes, we'll have a roll call.
Mr. Lawrence Larry Bisconti. Absent. Miss Claudia P. Georges.
Present.
Present. Mr. Harry A. Daniel. Absent. Wilma Marsh Monsanto. Yes, Wilma Marsh Monsanto.
That's right. Present.
Miss Lydia Hendricks.
Present.
Miss Alicia M. Wells.
Yes.
Mr. Arturo Washington Jr. here. Mr. Delbert Bryan. Here. Mrs. Liliana Belado D. O'Neill.
Present.
Mr. Roland Molina. Here. Mr. Glenn Wester. There. Mrs. Lisa Harris Moorhead.
Here.
Mr. Rupert Ross Jr. Here. Mr. Raymond Williams. Madam Chair, 12 present, 2 absent.
Thank you very much, Mr. Secretary. I'd like to welcome Mr. Marvin Forbes, who's of the BI Action Group, and also TV2. I'd like to welcome the persons in the audience. This is nice. We like seeing this. And we hope that the information we're going to disseminate today would be whatever you need. If you need any more, just please ask orderly. We'll now continue with our agenda, and we have the report of the St. Thomas St. John District Board of Elections. Memorandum to
Good morning, fellow board members. The St. Thomas St. John District Board met on yesterday. We had the forum of 5 people present. They were Claudia Georges, Wilma Marsh Monsanto, Lydia Hendricks, and Wells, and Arturo Washington. Our agenda, including the discussion of the Uniform and Overseas Citizens Absentee Voting Act to consent. I'm sorry, and we also had present our legal counsel, Attorney Salisbury. We discussed the UOCAVA and the consent decree emanating out of that act. Specifically, we discussed and we adopted a resolution that we hope to present to the joint board in terms of at least a starting point in the discussion on where we think the possible dates for the starting of the election cycle should go. Our other agenda item was the discussion of training for members, and we have some proposed dates that we would like to also offer to the membership to determine when in fact we get a deal for a good time for the joint boards to come together to discuss items of procedure, legislation, and policies that they would want to see take place during this term. Our other agenda item was voter education. We did not take any specific action on voter education, but we do want to emphasize that we believe it is our duty, especially when we adopt these new dates for the election cycle, that we start educating the public, because it will condense the period of time for candidates to become prepared to participate in the election, and of course the voters who would be participating therein. We also had two motions that were made. One was ruled out of order. A motion made by Member Wilma Marsh Monsanto to have the Board of Elections, at least St. Thomas St. John District, in fact vote on the type of ballots that would be used in the next election. I ruled that out of order because that is in the domain and jurisdiction of the legislature, but not the St. Thomas St. John Board of Elections. And the other item that came up involved a letter from Ms. Diane McGrath, wherein she indicated by letter dated April 12th that she was requesting to examine and copy records, the tally sheets from the 2012 election. That spurred some conversation even prior to that letter being read into the record. Another motion was made to direct the administrative assistant to produce those tally sheets by today, and that motion was voted down 3-2, and thus that didn't take place. However, I think most of the members, or at least the chair, and at least one other member, took the position that the candidate has a right to examine. Well, I think the entire board agreed that the candidate has the right to examine all the green tally sheets as requested, and we will endeavor to do so. The problem of the availability stems from our departure of Deputy Supervisor of Elections in St. Thomas District, who coordinated the move from Crystal Data to this building, and as such, those items have not yet been located, embarrassingly so. But we'll endeavor to find those documents as soon as possible, and Ms. McGrath will be so notified. And the board, in fact, examined and went over the appointment of our acting Deputy Supervisor in St. John District, Ms. Sharon Benjamin, which appointment document that has been prepared and was approved by the joint board will be again shown and given to the joint boards for ratification of the exact terms. That is the report from the St. John District. If any members feel that I missed out something that we dealt with yesterday and that the board needs to know,
Member Georges?
Yes, cancellations.
that was not an agenda.
That was on the new business.
Wasn't any agenda on the business, so we discussed cancellation. What should be done and how was it to be done?
We discussed the issue of cancellation. We discussed the issue of whether in fact we should begin cancelling without having the board having the opportunity to review the provisional ballots that may have been ruled not ballots, but that's those persons who use provisional ballots who are not eligible to vote. Basically, I don't think we didn't in fact set any date for cancellation, nor was a vote taken for any specific action on cancellation.
Sure. Member Marshall Sanders?
I believe Secretary Waddington stated the motion that I made. Is it possible that the motion could be read back as it was? About can it be read back? I think he misstated.
Which portion?
The one having to do with the matter of if we don't get the funding by September 30th, that indeed the voting instrument that would be used in the St. Thomas and Young District would be the paper ballot.
Yeah, it doesn't matter. It doesn't matter from any perspective.
No, it sure does to me.
But it was ruled out. I don't think it's necessary.
I'm saying
It's clear.
the way you read it,
I didn't read anything. I
agree, and
paraphrased.
you should be reading.
No, I don't have to.
You should.
I paraphrased what in fact action was taken.
Report should be written.
And the result was the same. The chair ruled it out of order,
That may be so.
and you didn't challenge the chair to get the votes overturned.
That may be so. But I'm saying you still need to write your report because you misspoke the motion.
Well, to paraphrase what was said, since he didn't have it in front of him.
Write the report.
Member Bryan, your
Morning.
report. Morning.
I have a particular concern with two statements or representations made. Did I understand Mr. Washington's secretary reported from the St. Thomas and John District that he ruled a motion of Member Monsanto out of order? That was the ruling, right?
Yes.
So there was a vote taken on it. There was a challenge, you said?
There was a challenge to the chair for his ruling.
But then he went on to say that that matter would be left up to the legislature. So it's not a fact that each election district certifies or verifies their own election results. In other words, on election day, whether it's a primary or a general election, the certification through the supervisory election, that's up to the St. Thomas St. John District. The St. Thomas St. John District Board certify the results of the St. Thomas St. John election, correct?
Yes.
And vice versa, St. Clair Board of Election, which is supervisory election, certify the election process and results of the St. Clair District, correct? Okay. Then another concern you mentioned, the last portion about I'm skipping a come up to them. Go ahead.
Okay, now it's time for your report, and then when if you recall it and see it, then you can just...
Yes, I will.
Oh, I'm sorry. I'd like to acknowledge the presence of Councilor Beckett and Attorney Salisbury. Thank you.
No, I remember the concern was, he made reference to a resolution of a joint board meeting where supposedly a resolution to be drafted to Sharon Benjamin to be in a position of acting deputy supervisor / administrator.
Yes.
And if you examine the records clearly, that effective date should be today when the joint board make the proper motion in this meeting and ratify it or vote on it, or we just going to accept the fact that the meeting is in court. The meeting was adjourned, meaning the agenda for the meeting has been completed after some of the members left. And then Mr. Waddington said he moved that we do these things. So how does a meeting that was adjourned with the agenda reconvene a meeting without notice of a new meeting or even an agenda for the meeting? And if you look at the transcript, you will see in fact the meeting was in fact adjourned before any consideration was made to Sharon Benjamin. Not I'm against what opposition might be, but if you adjourn a meeting that was published for anything in the agenda, you cannot reconvene an adjourned meeting just by saying I move to address the situation. If you read the transcript, you'll see it there. So I'm hoping that we can go through the right procedure today. And since Ms. Benjamin, the person have been selected to work at the St. Thomas and Grand District as administrator / acting deputy supervisor. That proper motion we made today, we can have it recorded properly and voted on. That was my concern when he in that reference. Thank you.
Executive session.
Thank you.
Your report.
Yes, ma'am. Our meeting was held on February 6th in St. Paul at 9:30 in the morning, and we had 11 or 13 items in the agenda. I'm not going to go through all of them because we had to wait for some information we haven't gotten as yet. So if we haven't got this, there's nothing to tell about the meeting. We didn't get to speak to the supervisor of election because she's out until May 21st, according to Dr. Prasad, and you're not going to be available until June 12th, 2013. Again, we had another meeting on March 6th. We still didn't get the report, so we were asking about close-out expenditures and certain obligations. We didn't get any balances for the current tax account of the system or the board. We didn't get a completion of the report from ES&S about the letter that was written to Mr. Abramson about the payment of the contract. I think the last time we had a concern where that there was a discussion between who was told when Attorney Salisbury mentioned that she told Mr. Weber not to pay because of what the questions were about the state plan. We didn't get that, and in the same motion we addressed the concern of Ms. Stephanie Barnes that made a presentation at the joint board meeting where she suggested that she was suggesting or recommending that from there on that we would keep our meetings in St. Thomas. I don't know what part went through her mind to move the meetings from St. Paul to St. Thomas. And just last week she said, oh, I can file a in St. Thomas. So I wrote a letter to Ms. Mellon, for you. Mr. Mellon is after the property procurement. Notifying her about the situation that Mr. Barnes mentioned. I haven't received any information or response from Ms. Barnes yet, or either from the Commissioner of Property and Procurement. And she explained all these concerns with the property and the building and questioned her if in fact the building is not owned by the government of the Virgin. We need to, or she needs to notify the Commissioner of Property and Procurement of the condition of the Sunny Isles Development Limited Corporation about the condition, because the Board of Election cannot and will not shut down the St. Clair Board of Election office while any landlord is going to repair in the property. All the things that she outlined here. So if that is the case, we need to find out from Commissioner Mellon what her intentions are in helping or maybe also help locate an office for the St. Croix Board of Election in St. Croix. Again, too, we had a concern about the Ms. Butley. She hasn't responded either with balances as the letter she wrote to Mr. Abramson, Mr. Weber about the $90,000. Up to now, we haven't seen an outline accounting of the money for $2.1 million that was set aside to purchase new machines for general primary election. Also wrote to a letter saying $90,000. She never told none of us at any meeting what is the status of the $2.1 million. Where is it? Is it deposited in the election system account? And who administers it? And why can't we use that money to proceed to pay ES&S? Because if the money is there and it's go to the balance to buy new machines for general primary election, then we should have the control and access to that amount of money. Once in fact we have been having an accounting report from Ms. Gottlieb, but she hasn't been here. The last thing I know, she was here at our meeting yesterday, but I haven't seen her meet with any response from Ms. Gottlieb as to what is being done with the money. Again, I was called yesterday after the meeting we had in April, had the same advertisement of position with the first supervisor elections, deputy supervisors, and one of our meetings was when Mr. Weber left abruptly. There was nobody in the St. Croix election system in the capacity to result in the Virgin School. So at our meeting we selected an individual and we're still waiting to see what we're going to do in that position. Nonetheless, Mr. Weber left a bunch of keys on his desk. When I went there, the keys were there. And the next day or afternoon, someone asked if I seen some keys. I tell him I left the keys there. He says those keys was Mr. Weber's keys on his desk and the keys from Mr. Abramson's office that he also had. I decided to call the locksmith and change the locks on Mr. Weber's door and Mr. Abrams' door, and also since he left the vehicle in the parking lot. The key was supposed to have always been in those bunch. The vehicle was left in the parking lot out to Sunny Isles. I called him the same day of the meeting, and the locksmith came and changed the keys from Mr. Weber's office, the keys from Mr. Abrams' office, and rekeyed the vehicle. Since nobody didn't know where the keys went, I called the police to make a police report of the keys, and that was where it was. Sometimes subsequent to that, the office is now locked, and the inspector general have inspectors coming in and out to look at these things. So in order to protect the employees who don't work in Mr. Abrams' office or work in Mr. Weber's office, when they come there, I've gone to let them in so they could get the exemptions or examine the documents in the one, because in leaving the office, lots of the files that should have been in drawers in the cabinet were located in the hallway in the office in St. Croix, so nobody really didn't know what was in and out of the building. So I know Mr. Abrams' office is empty, except for some VI code, computers in there, just the monitors on the desk. I don't find a report, I haven't seen a report from Mr. Weber as to what Mr. Abrams took or left his there with, and I think if something is missing there, two people to account for what is there would be Mr. Weber and Sergeant Abrams and anybody who helped to move anything. The keys that was taken off of the desk, whoever took those keys, I have those keys, I have to throw them away since they can't get to Mr. Abrams or Mr. Weber's office to drive the vehicle. But in addition to that, the keys to the back door and other places are also missing. So when the time is correct, when we finish, I guess we have to call the locksmith to get keys for the back doors in case of emergency there. And in addition to that, OSHA, the young lady from OSHA came yesterday and compiled some of these things here so everybody can have them. And she made an inspection. I was at my farm as usual, and Ms. Johnson called and told me that someone from OSHA was there to walk through the building. So I said, let her walk through, I don't live there, so anybody can walk through there. Ms. Johnson volunteered and accepted the task of walking through with the young lady. So they found a lot of things they claim need to be corrected and wrong with the property, and I think we need to move post haste to address these concerns with the landlord. Since you have a contract to pay these people, they talk about the breaker panels, the storage, the kitchen, and all those things. The report is self-explanatory. So basically, whenever the board or the property procurement official decide, we'll start to get in touch with us in St. Croix. And since Mr. Abramson is out on sick leave, I don't see him except driving. And since he's out sick, I know that I'll see what is wrong with him. I see him. And I understand that in the meeting, when Ms. Mohel and Mr. Ross appeared there, Mr. Williams, they told him that he's in contact with the office. And nobody in the office told me Mr. Abramson looking for anything. So I don't know what the conversations were between Mr. Abramson and any employee in that office. So if he's running the office absentee and speaking to employees in the office from the election system, I don't have no control and actually know what they're talking about. I guess the information is streaming between those parties who know what they're talking about. But absent to that, I can't tell you what Mr. Abramson is doing.
I have two questions. Thank you. The copy of the letter to Helen Young, you have a copy of that? But she never responded to the one you just
She
said?
never responded, no, sir. No, ma'am, sir.
And also, thank you. And also,
Hello,
this
you say
question
you haven't
of
seen it?
OSHA? No.
Well, you have to actually have to read
Okay, I'll
it.
he's here the book to be just take a look at it, yes.
Madam Chair, from March, Ms. Sharon Benjamin by email circulated a letter to all members.
Thank you very much. When the persons of OSHA came yesterday, were they able to go into all of the offices?
I guess they get it, the hard office, Mr. Abramson, to Weberson.
Okay.
So that wasn't legal while I was going to offices. They said that they come unannounced, so they can't unannounce. I live with them and they live with me, so they have to wait until I get it. So I get in the office because Ms. Johnson was in the building, and she walked them around.
Member Williams?
The chairman's report reflected some paraphrase of a conversation that suggested that members Moorhead, Ross, and myself had conversations or working conversations sometimes within the area. I want that to, that as a stricken on record because that's incorrect, number one. Number two, that is, I don't know where that came from because I never met witness Abrahamson at any point in any office, any meeting, or anything. So that has to be corrected. You know, we can't just unilaterally say things because we want to say that, you know, because it leaves the impression on the board and the community at large that these things are impactful, and if they are not impactful. So I don't know.
Excuse me, may I respond?
And O'Brien?
If we have a problem with what I've been saying, there's a transcript that was recorded. I was there when it was mentioned that Mr. Abrams still holds the position of supervisor of election. He has been in touch with the office, in and out, and by phone, and he is speaking to employees. And he's still in contact with employees. These three individuals were there at the hearing, and this is capable. All you need to do, get that transcript because it has been prepared, and you will hear what Ms. Monet was saying, and what was mentioned. I mentioned that all three of them were sitting there when the statement was made. So I have the transcript, but I looked for it and found it. I said that.
Senator King.
Okay.
Member Martin Santos.
I move that if funds are not available by September 30th to purchase new EAC certified machines for the St. Thomas St. John district, that paper ballots will be considered as the voting instrument in the district of St. Thomas St. John for the 2014 election.
Second motion.
It's been moved in second.
Objection.
One objection. Roll call on the motion.
Lawrence, Larry Bishoki, absent. Claudette Georges,
Yes.
Larry A. Daniel, absent. Wilma Mars Monsanto,
Yes.
Lydia Hendrick,
No.
Alicia Wells,
No.
Arturo Watlington, no. Mr. Delbert Bryan,
Yes.
Mrs. Liliana Delado de O'Neill,
Yes.
Mr. Roland Molina,
Yes.
Mr. Glenn Webster,
Absolutely yes.
Mrs. Lisa Moorhead,
Yeah.
Mr. Rupert Ross,
No.
Mr. Raymond Williams,
No.
Madam Chair, 6 yeas, 6 noes, 2 absent.
Motion is failed. I'll entertain a motion for us to go into executive session.
So move.
Objection.
One objection
Could you state the motion and purpose of going to executive session, Madam Chair?
for personal matters and for budget, personal matters and budget.
Madam Chair.
Can I have a copy of the information for this personal matters and budget? I don't have no documents on budget.
We don't have it.
You don't have
We
any?
have discussion on personal matters, ensuing, and there's
So then,
the one you really. I'm sorry, someone was making a point.
Yes, Madam
if you
Chair.
don't have
Madam
any,
Chair, Madam Chair, through the chair to Mr. Williams. Because we have, I mean, the personnel matters is a new business, but I think it's very important that we deal with the consent decree and the dates so that we can at least start, because of personnel matters may take a long time. We have a number of individuals who are here, who want to hear what's going on. And I think, if we're going into executive session, we need to have the time to do whatever we need to do in personnel action. And, it will just not allow the public to hear our deliberation, possibly on the items and to hear the reasons why for the changing of the dates to speed up the election. So I ask if you would consider, if you would even consider,
Motion.
would you would consider reordering the agenda. Let me take away the done motion and just amend it to reorder the agenda to deal with the
Motion.
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 Motion, Member Bryan.
Madam Chair, the motion is to order item E, new business, and make number item 2 and 2A, the first item in the agenda, and a new business, so moved.
Is there a second? Second. Second has been moved and second. Any objections? We're reordering the agenda so that the public can have the information in, no? None? Okay. So we'll go on to number 2 under E, new business, review the consent decree, and I'll ask members Wackington and member Moran, whichever one of you is going to go first.
I like to go first. Please. You want lady first. As I said in our report, we when I say we are referring to the St. Thomas St. John District Board of Elections. Of course, we might have had the opportunity to be briefed on this subject matter before this board, which was before our last joint board meeting. So from early last month, we have been pondering this issue of the consent decree, the reasons therefore, and what we have to do to comply with the consent decree. Ms. Salisbury presented to us before she presented to you why we had to do it, and I just wanted, just for the record, state it on the record. She prepared a document that indicated that there exists the September 7, 2012 consent decree between the U.S. Department of Justice and the government of the Virgin Islands, which requires changes to the primary and general election calendar to provide sufficient time between the dates established for qualifying candidates and the 45-day deadline for the transmission of absentee ballots to bring the election process into compliance. And these discussions have been had with the supervisor of election, who is on extended sick leave, and has now been discussed with the St. Thomas St. John board, I believe, and the joint boards of election at our last meeting. So yesterday, the St. Thomas St. John board, with the 5 members unanimously agreeing, came up with some dates that we would like the joint boards to consider, and and they want to change them around, but we discussed them extensively, and I have a written document reflecting those changes, or those suggested changes. The only thing that would be added is in the category of number 1, the filing time for nomination. We said the filing time was suggested I would be the 2nd Tuesday in April instead of the last Tuesday in June. And I would like, and this was not discussed, I would like for us to put a time by 6 p.m. Right now it's by 5 p.m., but I'm suggesting that nomination be closed by 6 p.m. rather than 5 p.m. For those people or candidates who may be stuck on the job and things of that nature, it may be a lot easier to make a deadline of 6 p.m. rather than 5 p.m. on that last Tuesday. I'm not sure, and I don't want to jump in front of the St. Croix district in regards to what you may suggest, because I believe we can compromise in terms of the date. But our suggested starting dates were in fact April, that first, the 2nd Tuesday in April to begin the process.
Can I ask you to explain why it's so far back?
Well, yeah. Why so far back? Right now, our primary election, based on the legislative vote, is August. Attorney Salisbury, help me. It's right now August when? August 2nd. Is it August 2nd or a specific day, the first Saturday in August? I mean, by law. I'm asking by law, not necessarily. Whether or not the law. It's the first Saturday. So for next year, in August. So next year would be August 2nd. The subsequent years will be, we don't have, unless we look at the calendar for 2016, we know exactly what day it is. If we count backward from August, we will have to come back. If we come back from August, you're gonna see that June would be less than 45, not less the June, because after you get your nomination papers, after you file your nomination papers, there's a time for withdrawal of those papers, then there's a time for casting the lots, then there's a time for production of the ballot, and then after you do all of that, you need 45 days before the election to have those ballots in the hands of the people overseas. So to give everybody, the candidates, the system enough time to prepare and to produce and to send out those ballots, we determined, and one leader, one person who went through it very painstakingly is Ms. Hendricks. Painstakingly, we went backward to make sure there was more than sufficient time so that in fact we do not interfere, we do not violate this federal law. Let me finish. That's all that is my answer. What was initially recommended was that we start this process in March. We thought that was a little too early. We pushed it back to April because it gives us sufficient time. We did not want to take the chance of going 60 days before the election. We wanted to give every aspect of the process enough time to work itself out practically. That's the reason that we suggested the April date. Now, and anyone that remembers who had a discussion with him, and correct me if I said anything or I missed anything in regard there. Yes, Ms.
I have two concerns. One, that 60 days in excess of the time that you need by law to have people. And my other concern is this, that you have people, you talk about going all the way back to April. What you're doing is telling people who want to run that they have to be off of work from April. Unless you're working, as a senator, an incumbent senator, then you have to, you're appointing an employee, then you have to take off from April through November. And that means you're cutting down the number of people who can possibly run. You don't need that much time. That's my concern. I mean, if you look at the dates vis-a-vis the whole calendar, you can start in May and still have sufficient time. That's my concern.
Yeah. Well, the difference between May and April is about 1 month. And we believe, based upon our discussions, that it's most practical to start in April. And in fact, what we suggested is second Tuesday in April, and for the withdrawal, it would be the 4th Wednesday in April, the 4th Wednesday, and then the casting of lots will be the couple days after that, the 4th Friday in April, because once you get the ballot, once you get the nominating paper, the office still has to go through the process of determining the eligibility of all the candidates. You don't want to put your election system at a disadvantage in terms of rushing to get prepared for the election. So and I understand your point that it's going to put a little bit more of a bigger onus on somebody running for office. But running for office and participating in public office, it is what it is. It is a sacrifice.
But what you're suggesting is that the previous calendar should have made everything too tight.
Yes. The previous calendar definitely have made everything too tight, and I know if you've been on the board now, this is third year, fifth year. I have never, in the 10 or 12 years I've been on the board, I've never seen the calendar that the compliance, full compliance with the calendar, because the dates run up on you and when we don't comply with our own calendar. So I think this is not our calendar. This is a federal mandate that we may in fact lose. A federal mandate that, if violated, may cause us to in fact lose federal funds. So I think it's important that we don't put ourselves behind the eight ball.
I'd just like to point out wherever you see F-O-R-T, F-O-U-R-T. Member Brian?
I have a question. The consent decree, right?
Wait a minute. Member Georges, can you move those two chairs over to me? Please, thank you. I see in your eyes and not. Okay, thank you. I'm sorry, Member Brian.
The consent decree is between the federal government, or as it is represented, the Attorney General representing the Board of Elections, right?
Yes,
Okay.
the government of the Virgin Islands.
Right. If the Attorney General office is the one representing the Board of Elections pursuant to the statute.
The government of the Virgin Islands.
Yeah, same thing. The letter that I have here, it says compliance to inform and oversee citizens of Sati Voting Act. And it has a last page, says Kimberly Salisbury, Assistant Attorney General. Is this your representation? Right?
That's what I'm presenting to them.
This is what you represented. This is what you recommended in your consent decree and so on. So then, I was looking here and these changes that Mr. Waterton is claiming that the board changed on this.
For the record, Madam Chair, I am not claiming anything. I said what was voted upon by the St. Thomas St. John board on yesterday. I'm not claiming anything. For the record, I'm not claiming anything. I'm saying, representing what the board voted on yesterday.
You represent who the board voted on, correct?
Yes.
Okay. So then, when the board was voting, was the Attorney General present?
Yes.
And Attorney Salisbury, did you receive a satisfactory certification where the changes you did? Or is it contrary to what you wrote and gave us?
No, I'm sorry, Attorney Salisbury.
I can't hear people talking the same.
I'm just saying Attorney Salisbury.
Okay.
I'm really happy with these dates, pushing it back.
So this document,
Second Tuesday in April.
the document that Mr. Waddington representing from the board wrote, you concur with what they said, right? Now,
This isn't a legal question. Setting up these dates is really for the supervisor's office, and then having enough time to prepare the ballot and get the absentee ballot ready to be mailed out on June 18th. It's not a legal
so
question.
if that's the case, why do you recommend these changes that to be complied?
To get the board started to talking about it.
I know.
There is a letter due to the U.S. government in June, and they want to know what we've been doing. So in an effort to assist the board, I threw out some dates.
You just throw them on.
To get.
So you don't have no problem with those that you throw being changed for these?
No.
No. You have, on your paper it says, additionally, Title 18, TVIC 232, it needs clarification to avoid future litigation such as maritime was over the election. Have you come up with legal language or suggestive language to address that concern, right?
I have not.
So, when is this going to be addressed? The Attorney General is the legal counsel to address this suggestive language with the maritime fees over the election.
The attorney, I'm sorry. Yes.
Or is she going to give us some suggested language since they're going to represent the process?
Just a minute.
Through the chair to Member Bryan. Member Bryan, one of the reasons we didn't, this wasn't the other items that was part of Attorney Salisbury's memo to us, was because they don't have anything specifically to do with the consent decree. What she was suggesting was some other items that we need to look at down the road. But because we have some deadlines with the consent decree, specifically in June, these other items we did not consider at this time. We didn't consider them to be as pressing at this time as these in the consent decree. We have enough time to sit around and discuss the other items, and Attorney Salisbury understands that these are the items that the 5 items that we have discussed and that we voted on are the items that are time sensitive and time driven, and that the other 2 items that she has brought up in her memorandum would be deliberated on by the boards at a later date.
So then, through the chair, Madam Chair, if this is what is being said here, and you change in dates for filing and all those things. When you have a filing for primary, these things need to be addressed so you don't run into the same problems. Who won't pay for the primary? Or who's going to take care of that? So when is Attorney Salisbury, anybody from the Department of Justice, going to come up with recommended changes to being compliant? Because if they to advise and represent, they should do that, not to wait until last minute, until we get, because there's a timetable to get this addressed. I would like to know what the recommendation of the timetable. If she can tell us how soon she can come up with any recommended changes. Because even if she comes up with any, the district board or the joint board can still change them to be another. So I want to have something in writing from the Attorney General office, what their findings or recommendations are, versus what the board changed to meet their desires. And that's all I'm trying to find out.
Attorney Salisbury?
Yes, I'd like to respond, because this is not a matter for the Department of Justice. This section of the code refers to the Board of Elections' responsibility for certifying the process to be used. The board has to make a decision on whether they believe or want this section to mandate public funding or private funding. It has nothing to do with the Department of Justice.
So
it's your job to come up with what you want this to read and then make that recommendation to the legislature.
So the Secretary, the Chair of the St. Thomas and Young District, yesterday we voted on this document by the Attorney General in its entirety, as it states here, with some changes made in the date, but it was in its entirety. It was voted on and it was passed, except some changes were made on the date. This morning we come with this now, and I think what Member Bryan is saying that he's looking at both pieces of correspondence. This is the one that we voted on yesterday, if I remember correctly.
But
let me finish.
But when you say this, so that the record should reflect what you mean this, which one are you referring to?
The one here done by the Attorney General. Here.
The first date,
This one here, the September 7, 2012.
Most of them start.
Okay, this one, the one...
One is 2 paper, one is 1 paper.
The two pages, the one with the 2 pages. Okay, 2 sheets. So we voted on that yesterday, and it was passed.
That's not true.
Okay? A motion wasn't made to accept
Wait
this?
a minute.
A motion wasn't made to accept this?
Through the chair.
A
Member,
I did say...
say something?
I did say a motion was made to accept this document with some changes made in the dates.
Which is this document here.
Okay, in the dates. But if you accepted this, then you would need to accept this in its entirety.
No. Madam Chair.
Okay, Member,
I'm just asking the question.
Hold on to your point.
I'm just asking the question,
hold on.
Because you have this document done by the Attorney General, and then this one is done by whom?
Member Watlington?
Yes. Madam Chair, at yesterday's meeting, we went through the 2-page document. We discussed 5 items out of the 2-page document which is reflected here on the document that has been distributed to you. You voted on these dates, Ms. Marsh Monsanto. The 5 items that are here, this is what you voted on. Furthermore, you are the one who made the motion to adopt these 5 items as the item that we would be presenting to the joint board today. We did not discuss any of the other 2 items in the council's memorandum that she shared with us many months ago. These are the 5 documents, and I said yesterday I will in fact type it up and put in the date that we agreed upon yesterday.
This is the document you presented yesterday, and the changes were made in the days. We worked on the changes.
And these are the dates today.
That is true, but I'm saying it is still a deception, because this is what you present. I even asked, are you going to fax a copy to the chairman of the St. Thomas St. John district so they can have it to be here today? They would have been able to discuss and come in. I asked if you would share this information with them even yesterday, so that they can be prepared today to deal with it.
You were here yesterday. You know what we did. Please
There's absolutely
clarify.
no deception
None.
whatsoever. We never spoke about Section 232 yesterday. There was never any motion to adopt anything relating to Section 232. It only pertains to the first 5 sections of the
But he is asking, and you're not answering the question that he's asking, because he's dealing with a document that you presented. Did you have a change of heart? Did you just change the dates?
Well, this was excuse me. This was, excuse me. Attorney Salisbury was here. We looked at what Attorney Salisbury had said. Attorney Salisbury was here when we did the 5 items, and it was voted on after the motion that we bring it to the joint board today.
I
It
was
was
here by
brought to the joint board. The only thing I said differently is FORT should be FOURT.
I hereby rescind my vote on that.
That was yesterday.
Yeah, I know.
That was
I
in
let the
district
record
board.
show that I rescind that.
In a district board meeting.
I rescind that. I know we can't do it. I want the record show, because I needed to submit something in its entirety, and we did change something. What happened to the rest of the document?
Those are the only.
And that's what he's asking you know about the Mark Hatch case, because it's in this thing here.
All right, you can rescind that one.
No.
Next district board meeting.
I have a point of clarification. All I'm trying to ascertain is I have this document with Attorney Salisbury, and that is, she represents, that's her. Because when I compare it with what Mr. Waterton said, just now he typed it here on the vote. I noticed as an example, type 18-350, withdrawal of candidate change the first Monday in July to the first Monday in April. We go to the same item that Mr. Waterton said he prepared. It says, Title 18 VIC 350 withdrawal of candidates, right? It says change the first Monday in July, right? Right? To the 4th Wednesday in April. But this one says the first Monday in April, so the 2 of them are not the same. So I just want to make sure that Ms. Attorney Salisbury accepting of questions to what they changes as her presentation. That's all I would tell. When we reach the court, if I'm there, I want to be sure that I accept what the attorney who was advising us and representing us said was comfortable for her as opposed to what we're talking about. So if it is comfortable with Attorney Salisbury and what Attorney Washington said he represented, let's go.
As you said it was, Attorney Salisbury.
Yes.
Okay.
All right. By the way, it was a chair, that's why I was asking the question. Thank you.
Any member Ross?
If I may, I'd like to contribute to the dialogue. I understand the rationale based on the decision that was made yesterday, even though I have problems. I don't support the idea that that we should make it difficult more than possible for people to run for public office. I understand that as a member of the board, I should also be concerned as to whether the staff has enough time to do what they need to do. But putting those two things on a scale, I would come down on the right of people to run for public office, giving a better shape and deal with the issues of the board. That's one. Two, I do have a problem. Second Tuesday in April, and I'm very presumptuous. I'm looking at Easter Sunday or Easter Tuesday after Easter Monday. Hang on. I'm looking at an election system working in the heat of conflict to complete this work. I'm more comfortable with early May. And again, we equivalent, as you say, second Tuesday, I said, first Monday in May, whatever the case may be. So basically the 3 weeks apart. The requirement of the board is to comply with the consent decree. It's basically based on what the legislature has established. It's having the first Saturday in August being the first February date. It means that the board, when it constructs its working calendar, must distribute the ballot, mail out the ballot by the second Monday in June to comply with that 45-degree issue. And if we agree on that second Monday in June issue, then the question is whether or not we need 55 days for the election system, 60 days election system to prepare for the second Monday in June, or they can do it in 45 days, starting with the first Monday in May. And lastly, whatever we do, it's my understanding, in terms of changing these dates, are going to require changing existing law. Because all these dates were generated by current law in code. So that I think that the joint board will comply with the consent decree provision of making a report by June 1st. If the joint board does, by judgment, a couple of things. One, establish these hard core dates that are necessary to meet the 45-day requirement. Two, identify those sections of the law that would require the legislation to act and submit it to the legislature. So that when we submit it to our report to the U.S. Department of Justice on June 1st, we can say that these are the things we have done. We can't do more than that until the legislature acts eventually anyhow. Whatever we do today is going to be subject to the legislature's, the senators' appreciation for the electoral process. They may not agree. They may not agree with the May 1st date either. They may agree with the April date. I don't know. I'm not going to quibble with that at this point. But they're going to make the final decision. We can only submit the information support. And my understanding of the NASIS, I'm going to stop. My understanding of the consent decree is that we have 3 reporting dates. One in June, basically, as I read it, is a sort of a progress report. Tell us where you are, how far you have moved down the road. One in the end of December, tell us whether all those laws that need to be passed, etc., have been in place. And the end of January, tell us you're in full compliance. So we're not in a position to nail it down on June 1st. So we will work at it, measure it, and take enough time to make a decision. That's basically my comment.
How inquiry?
Since it's coming from the joint board to be directed towards the legislation will have to make the final decision.
How inquiry?
Lisa, Member Moore and then Member Bryan.
I agree with basically what Senator Ross said. If we move it back to May 1st, that still gives us 60 days as opposed to 45 days. Because May 17th would actually be 45 days, so it would be 61 days. May 1st is on, and this is just a suggestion, May 1st is on Thursday, May 2nd is on Friday. So you could do the first Friday in May, and we would have more than ample time. I don't agree with the concept of bringing it that far back for the same reasons I've already stated. The only other thing I want to add is that June, according to the president of the legislature, from what he told the council's office, is the month that he's expecting to see election reform stuff. So not only do we have a deadline of telling, working with the consent decree and giving them progress report, if we want them to vote on some changes by their September session, which is our next reporting date, then we have to have our recommendations.
Member Bryan and Attorney Sullivan.
I have a question and a concern to the Attorney Sullivan. In the consent decree, the defendants in this case, when they say the territory, are they implying, they're speaking about the executive and the legislative branch, or just making reference to the board of elections, the Thomas and John, Mr. Abramson, and Mr. Board's election? So if in fact this joint board come up with a compliance to the consent decree, so make the recommendations and writing to the legislature to change the law, doesn't that in effect remove the joint board and Mr. Abramson and Mr. Board's election from being in violation of the consent decree versus they will have to move against the legislature? Because the legislature don't change the law after we give them all this information. Our only defense is to tell the justice, hey, we give it to them. So if the legislature don't change the law, where are we as a board? So then we are satisfied the consent, right?
Yeah.
So then the next move will be against the whole government of the ordinance, except we were speaking about the legislature who makes the law, the first branch. So there will be the legislature versus as defendant and the Justice Department of America.
The legislature is part of the territory.
And they will be defendant. So once we give them this information, then we can't do anything else other than wait for them to change the law. So we're here because they didn't change the law, and we went along with they that changed the law. So when we give them information, in that case, then the legislature will have to answer as to why the territory is not in compliance because they make the law.
If they don't.
If they don't make the law. So then if we give them a proper recommendation, they still don't agree, as Mr. Ross is saying, their switches are wrong, then we don't have a problem. But in addition to the concern that Mr. Ross is making about making it easy for the candidates, the way to make it easy is just like how senators and board members and everybody can remain in their jobs and don't have to take leave without pay. Everybody shouldn't have to take no leave without pay because the senators campaign all year and they don't take leave without pay. So if we make a recommendation to change it, that should be a part of it. And according to 410 and 411, examinations and certification of candidates, they need to have a requirement and a questionnaire for being convicted of a crime of moral turpitude or crimes against the revised identity act and the version. That must be on the questionnaire. Else we ain't doing nothing. So when the time comes, we have to get that consulted. Because the legislators have, what they call it now? sub silential, the ones that feel like they didn't understand, they do not. We have a clarification. So if we make it a requirement, our 410 and 411, that question, maybe have that question, they will move on forward. Thank you.
Oh, my understanding is basically what is getting assistant treasurer state. I just want to show the board that the consent decree is not a consent decree against the election system. Consent decree is a consent decree against the government of the Virgin Islands. And until the government of the Virgin Islands complies with that, and we're the instrument, by the way, let me put it the other way, we're the instrument through which the government complies. We set the calendar, we set the election calendar. But until the government of the Virgin Islands complies, Board of Elections, legislature, and the government, the consent decree, I try to tell you all, the consent decree will not go away. And the reason, one of the reasons why the Attorney General has signature to the consent decree has nothing, not because he represents the woman, he also represents the governor. And if we don't comply, they're not the one who say you can't conduct an election, then they go after federal funds due to the territory. So it's a whole holistic approach. The whole system has to comply with the federal law. I just wanted to keep that in mind.
Still right, and I don't want the impression to be left that because we do everything that we can possibly do, that we would not still be part of that extended group. Nobody's going to remove us from the case just because we do everything that we're supposed to do. The board has been doing everything we're supposed to do. Some of these changes were suggested for the last, I don't know how many years to the legislature, and they have used the rules back the primary until recently. So they moved back the primary, which of course gets us to the point where we are now, that we have to move all these other dates. And it's not just these 5 laws, but all of these dates on the calendar that are affected by the change. So, it's all of these dates and all of these code sections. It's about 20 code sections that are affected, because everything that is on the old calendar that has some code section is all affected. It might not change the actual wording of the code section. In some instances it will. So in some instances it will refer to an exact date. In some instances it will refer to how many days before or after something else. So you have to look at everything holistically and
I think Member Ross raised a good issue with respect to carnival on St. Thomas. And if you look at the 4th Friday in April, that is a good day to observe. That is not a good day to have the deadline time estimation. I'm worried about it being that.
Motion.
Listen, let me get a...
Remember we had a discussion, and the 4th Friday of April is not necessarily the children's birthday. It's a possibility that it could be. So you can, it doesn't, that's a Friday. So it doesn't matter to me whether it's April, whether it's May. It doesn't really matter to me personally. However, keep in mind, whenever you change these days that we have bandied around and agreed upon and discussed, you're going to have to push back. You don't take into consideration that we have did, that we have. The casting of lots. The casting of lots only occur, I believe, after the inspection of the nomination paper, okay, which takes some time, because it should be examined to determine whether or not the people are eligible. So there must be some time between the nomination of the casting of lots. So if you want to, push back the casting of lots, you could, and it doesn't really matter to me. All I'm saying is let us not fall into the trap of setting timetables that we cannot comply with in terms of the administrative work and the production of the ballot. That's the major concern that I have. I really don't have the concern that Attorney Harris Moores has, or Mr. Ross. Those of us who want to commit ourselves to run for public office understand the responsibilities and what is involved when you declare. They've already had people already declared to run for governor. There's been already one declared candidate out there that is actively have a website and is actively campaigning around the Virgin Islands. And the intention is, if we even consider it, it's right now it's a year out in terms of that. So I don't have a problem with the candidates, because the candidates will show themselves by January. Trust me, candidates will start coming out for the big elected position by January. Here in St. Thomas, by Carnival, all who's going to be running for legislature takes that opportunity, most of them take that opportunity to start their campaign. So it is not that we are putting people, forcing them to spend more money or forcing them to become more participatory in events, because they would have already started by these dates. So that's my only concern. My only concern is just be mindful when they start pushing it back, you're pushing back everything and it becomes a little bit more crap. As I said, that's all I have to say.
Member Webster has the
I have a motion, I make a motion that we adopt these 5 items with the change that Mr. Ross suggested on item number 1.
Is there a second to that motion?
They all have to change, it's
You can't do it peacefully. The motion is, was there a second to the motion?
I didn't hear the motion.
We have to, you can't do it peacefully because one thing impacts all the other as well. So can you hold your motion so you can have some more discussion and information given, and then you can get a better idea? Because one thing impacts the other as a thing. Yes? Yes? Member Webster?
She's asking, will you hold your motion?
Yes, yes.
All right, Member Moore and then Member Brown.
June 17th would be the drop dead date to mail ballots in order for them to get there, in order to comply with the 45-day prior mailing. So if we back that up and make it like June 2nd or whatever, June 3rd, and we're backing stuff up to May, you still have over 60 days, which is more than enough time, in April time, and it still gives you more than 60 days, which is, I would think enough, and I mean, I don't know if Member Washington disagrees, but I would think it's more than ample time. It's giving you 2 weeks longer than the federal requirement. So that would mean that you would start your process. The deadline for people to select a party emblem would be like May 2nd. It would be the first date that somebody has to comply with, and then your captain of lots would be in the middle of May. So it still gives you plenty of time. I mean, I think all we need to do is compromise with respect to time, and if the body will allow me, I can do this and have a calendar out to you on Monday, which has everything. Well, wait a minute, let me just finish. Which would have everything starting with May 2nd.
Member Hendricks?
Good.
Okay.
I agree with you in terms of compromise these days. I don't agree that you should try to do anything with any calendar, because in fact it is not. We have not changed the law, and we don't need to be getting involved as if we put in forth an election calendar that doesn't exist. That when if and when it passes, whatever passes, then I think we go ahead and amend and determine the calendar. But I don't believe we should get involved in all those dates right now. You see how much trouble we have right now in terms of just by 5 items, or 4 items in 4 days? I think we need to.
I can pick those 5 days from here as well.
All I'm saying to you is the calendar still would be of no moment until the law is changed, until we know what the state is like.
I
Okay.
was saying that I can pick those 5 day tabs that we're talking about. And what we're still talking about is mail-in at the ballot. At the very end of May or the very beginning of June, which gives you again more than 60 days as opposed to 45 days.
Once Member Ross is, and I'd like to hear, excuse me?
No.
Attorney Moore suggested to get, I don't think you should use the word calendar, get something to us like Monday. Member Ross?
I like the motion. I like the motion.
No.
Other information, Member Webster?
With Member Webster's permission, can I make the motion based on what you were saying earlier? Yes, thank you. The motion is that the process, what's the first day begins? First Monday in May.
Whatever name it.
Whatever day that is. First Monday in May. And I agree, by the way, even though we have little discussion on it, I agree that 6 o'clock, in my judgment, would be a better time for filing hour than 5 o'clock. First Monday in May.
What are you saying, Kathleen?
Filing.
Filing for nomination.
First Monday to start.
That's the
It's not, don't say 50, kind of change that.
It changes every year. The legislation is the first Monday in May.
By 6 o'clock.
Right, and that the mailing date, for ballot be by the second Monday in June.
Is all that the first?
And it's not in the well, that's the only day I want to change.
But
would it impact the others?
it's happened to me.
That's what what's the change? What impact the others?
Can we? I hear what I'm being asked to do, but I have not gone through this in detail. All I want to do at this motion is establish the filing date is the first Monday in May.
That's the same thing as the Webster.
That was meant for Webster one, and which I think consensus will reach that.
And I said,
If we agree, if we vote on that, then, or someone wants to amend it,
Excuse me, the motion is that the filing date be the first Monday in May. That's your motion. You're not doing anything else that we asked Mr. Webster because it impacts the other.
objection.
And there's an objection on there, and was there a second? Was there a second?
Second objection,
There's 2 objections.
amendment to the motion.
Yes, you may.
Okay, my objection for.
Raymond
Okay,
and Member Bryan's objection. Raymond had an objection?
No,
All right, Member Bryan?
You know, I still want to find out if we want to be in compliance, or we want to remove it in the parade or carnival. I mean, everything else is over these things. I mean, if we seriously setting this to be full compliance. Now, everybody that's going all kind of things to go to Juve, they go shopping, they go pay the bill before 5 o'clock. They reach the bank before it close. And you tell me, party candidates can't find a stage before 5 o'clock? And 500 they came out shopping? 2,000 Juve. She attacked in the morning. And we changed the day because we go carnival and cheer up.
So you're not for changing to the first Monday in May?
No, leave it. They agreed on one thing yesterday. And to add to this thing
Let's
here,
have some
Listen to what I'm saying. To add to this thing that we're doing here. We say I had a meeting yesterday that agreed with Attorney Salisbury to change these dates. We're going to change them again today. So then it means that all of us should wait until today to set these dates. We know that. And right on the paper, Mr. Watkins said that he type up what the board agree on. Who in the board yesterday talked to Mr. Rose? So right here it says, the supervisor of the election and I have discussed the parliamentary. When I talked to Mr. Rose, that's when you, but when you spoke to Mr. Rose, when? Yes, ma'am.
You're right.
Please be still.
You see what I'm saying?
All right.
A long time ago. So I'm saying it had to be a long time ago before you were told on sick leave. Right? So from then to now, what difference it make? You make a difference in the representative something and they have here, so because that's what Mr. Watkins. I want to know when I talk to this man who is part of the board. If you talk to the man from the board and nobody don't know who you're talking to about where, then we should know who you're talking to. If you represented him, because he's a part of our employee, and you're speaking to our employee and we don't know what you're talking about. That's all I'm saying.
I'd like to have a 3-minute recess.
Lawrence Bishotti, absent. Lawrence Georges,
Present.
Harry Daniel, absent. Wilma Mas Constanzo,
Present.
Lydia Hendricks,
Present.
Alicia Wells, Drew Watlington, here. Delbert Ryan,
Yeah.
Liliana Belado O'Neill, absent. Roland Molina,
Here.
Glenn Webster,
Here.
Lisa Harris Moorhead, Rupert Ross, Raymond Williams, Madam Chair, 11 present, 3 absent.
I want to call it the just
Second.
Any objection?
Yeah.
One objection. The previous question, Member Watkins? Or Member?
I think that the previous question actually was Mr. Ross's motion, but I don't think he completed his motion.
Return on the question, he didn't complete the motion. Well,
My motion, and so that you can be guided by my motion, my motion is that the filing time for nomination be established as the first Monday in May by 6 p.m. Under 2, that the withdrawal of candidates be the 4th Wednesday in May. Under 3, casting of lots be the 4th Friday in May. And sections 4 and 5 remain the same.
So we're changing everything, that's a day for
Second motion.
It's been moved
Second.
Any objection? Any objection?
yes.
Objection. Roll call. One objection noted. Roll call on the motion.
Me. All the April.
The second one and the third one is May, and the fourth one stays the same.
Lawrence Bishotti, absent. Lawrence Georges, Harry Daniel, absent. Wilma Marsh Monsanto,
Yes.
Lydia Hendricks,
Yeah,
Alicia Wells,
Yes.
Arturo Watlington, yes. Delbert Bryan,
No.
Liliana Bernardo de O'Neill,
Yes.
Roland Molina,
Yes.
Glenn Webster,
Yes.
Lisa Harris Moorhead,
Not voting.
Rupert Ross,
Yes.
Raymond Williams.
Absolutely.
I mean, yes.
Absolutely.
Madam Chair, 10 yeas, 1 nay, 1 abstention, 2 absent.
The motion is carried. We don't have this retyped in the beginning.
If you like, I would
Please.
Me,
Entertain
How about
a motion
inquiry?
for, excuse me,
Inquiry.
point of inquiry.
The nomination petition papers questionnaire, they be paid by district, right?
The nomination petition question is big.
Questionnaire they give me. You have a yellow, pink, and blue or something like that.
Office of Supervisor of
Yes,
Election. Yes.
Who prepares? The language on the questionnaire is prepared by district or by the joint board?
That's what it is. I think that's what not.
Yeah, it's written by code.
Yeah, I think that's what cool. I don't know that.
By code.
It's by the office of supervisor, not the board, the district board.
So the supervisor election prepares the questionnaire
Correct.
Yes.
under the direction of the board of election.
No. That's not what the law says.
Legislation.
Give me a second.
Check 232 and 410 please.
232
411
and 411.
If the supervisory elections involve the joint board of election, then how a supervisory election on his or her own can examine and verify the qualifications of the candidate without the joint board who is employed having an input on what the question should be or should not be? So the last time I think Mr. Abramson mentioned that he wasn't going to get ambulance unless the courts or the hospital, the jail, or the cemetery tell you somebody is dead, we don't need to be concerned about it.
We're reading over legislation section 411. Attorney Salzer, you have some comments on that inquiry? You don't have one? Oh. And the Ross?
I hear what Member Bryan is saying. But the law, and I stand to be corrected, the law, as I read it, clearly states that the process of determining candidates and nomination rests solely with the supervisor of elections. If you're suggesting that the board will give them some guidance, that's a different issue. But ultimately, the decision rests with the supervisor of elections. And my recollection is that in case of Daniels versus the board of elections, when we win before Judge. The judge admonished the supervisor for allowing the board to interfere with the nomination process. But we could research that. That's just my recollection. Right.
So then if the board is interfering with the election process through the supervisory election, who is in
The nomination process.
Nomination process, right?
No, but that didn't have anything to do with the nomination process. It had
No.
to do with the ballot,
Right.
formulation of the ballot, not the nomination paper.
All right, he was referencing, the argument would be,
It was a ballot.
no, the judge also made reference to the ballot.
But that's what the issue was. Only the ballot.
Would you recognize this?
Excuse me?
Anyway, you research.
Attorney
The
Salvin,
nomination
you have
process is
anything to
still
add?
a function of the.
Attorney Salvin, would you like to make a response?
I'm not really sure I understand the question. Are you asking who prepares it, or you want to know what's in it?
The preparation of the eligibility for examination under 410 and 411, right? It says that the supervisor of elections is the one that examines the petition to determine the eligibility of each candidate, right? So our question is, can the board, whether joint or district, with the supervisor of election, put certain concerns to be placed on the questioning for each candidate?
In the affidavit?
Yes, ma'am. Because somebody is sworn to.
What's on the affidavit is in the code in section 383. So that would be a legislative change.
Right, so that's what I want to be sure.
Okay. I'd like to entertain a motion.
Motion, I have a motion. I have a
It's
motion.
moved in second here. Can you say?
Objection. I have an objection.
Okay, roll call.
Roll call on the motion to go into executive session.
Lauren Bashalte, absent. Claudia Jordan, roll call.
We have one motion.
There's only one motion on the floor. To go into
The word
executive
executive session was objected to by Ms. Georges.
Because she wants to make a motion.
I need to understand.
Okay. Claudia Georges,
No.
Harry Daniels, absent. Wilma Mas Monsanto,
No.
Lydia Hendricks,
Yes.
Alicia Wells,
Yes.
Duro Washington, yes. Delbert Bryan,
No.
Eliana Bilal Leonid,
No.
Thank you.
Roland Molina, no. Glenn Webster,
No.
Lisa Harris Moorhead,
Yeah, no.
Rupert Ross,
Yes.
Raymond Williams,
Yes.
No,
Madam Chair, 6 years, 6 nays, 2 abstain, 2 absent.
Motion.
I know.
This is based on the discussion that we had at our last joint board meeting in executive session. My motion is for the joint board chair to establish a committee to investigate and recommend to the members of the joint board the method to be used to properly dispose of the obsolete voting machines. So moved.
Second.
Interesting.
For the joint board chair to establish a committee to investigate and recommend to the members of the joint board the method to be used to properly dispose of the obsolete voting machines.
The objection?
No.
No, okay. Motion is carried.
Thank you.
So ordered.
Okay, let me make sure I didn't get correct.
I'll write it up and bring it to you.
Okay.
I have it there, you want
Well,
it?
just, yeah, well, if you have it in writing, let me just staple it to get a copy and staple it to the sheet.
Is there any other motion to come before the body?
Yeah.
Motion.
My motion is to the joint board to officially correct the error of the nomination of Mr. Sharon Benjamin to the position of acting deputy supervisor / administrator effective date has been so moved.
Please restate it.
Object.
Objection.
That this board, the joint board today, vote on the nomination of Ms. Sharon Benjamin to be the acting deputy supervisor / administrator or administrative assistant, the same salary as previously mentioned in the original meeting I had in St. Croix, an effective date to be retroactive to the date in which it has been.
Second.
Okay, you seconded, Mr. Webster, right?
Yes.
Objection?
Objection and an amendment, Member Warren. Member Warren.
I would add that Tricia Johnson be made active deputy at St. Croix and from her start date
Is that, but that's,
It's an amendment to that motion, the second also.
second.
Objection.
Objection. Roll call on the amendment.
Point of order.
Point
Wait,
of
wait, wait,
order.
wait, wait. Hold on. Hold on a minute, let me get this. What do you got? I need some more, I need another roll.
She said that she got an amendment.
The motion was to,
Okay.
you have your, Member Brian, you have your motion.
Huh? I said it.
So we're going to do roll call on the amendment.
I don't understand the amendment. I don't understand. Is Mr. Johnson going to do 2 jobs for the at one also?
The motion is the same as the motion for Sharon Benjamin to substitute Tricia Johnson for the district of St. Croix.
With the same salary? Everything says the same.
Point of order.
Member Robinson, and then Member Molinar.
Point of order.
We're discussing the substance of the motion, correct?
Yes.
Okay. So my question. Okay, I don't have a question.
Member Molinar.
So the police acting deputy supervisor?
Yes. I need one question.
Okay, so roll call.
Point of
on the-
order.
I'm sorry, Member Brian.
I think if we're gonna start off correcting something, you can't make a nomination to adding something that's that germane to what we talked about. My motion is not germane to the amendment that Member Moore is making. I simply made a motion for correct a situation. There was no motion noted or any recommendation from Ms. Hilliard or any member sitting here today, whether Mr. Ross, Mr. Williams, Mr. Moorhead, Dustin James, Carmen Golden, or Anita Davila. In the absence of even from Ms. Hilliard, when she was leaving before Mr. Boba came there, they recommended Ms. Johnson to fill that position. And that was the case of been done long ago. But the whole process is a game that we want to play. So if we want, we're playing games since we already know on a witness inquiry, we made a motion that was voted on to pick a young lady that everybody has a resume to be the acting deputy supervisor. How are we going to dispose of that original position that took place in the state district?
So it can be clear, Mr. Secretary.
Just rule the amendment out
Mr.
of order,
Secretary,
let's proceed.
Call roll?
Yes.
Okay, we're voting on the amendment to Senator Bryan's motion,
No.
Mr. Bryan's motion, to have Tricia Johnson be acting
Motion is
supervisor for the district of St. Croix. Mr. Lawrence,
The
Mr.
motion
Larry
is not
Bushalty.
joking.
That is motion.
We
Larry,
voted on the
absent.
amendment.
Ms. Claudia Georges,
Yes.
Harry Daniel, absent. Loma Mas Monsanto,
No.
Lydia Hendricks,
Abstain.
Alicia Wells,
Yes.
Arturo Watlington, abstain. Adelbert Bryan,
No.
Liliana Palado de O'Neill,
No.
Roland Molina, Glenn Webster,
I'm not sure how we're voting on it.
is that abstain?
Voting on it.
Is that a yes, no, and abstention?
On the amendment?
Yes.
Oh, no, we already made a decision.
Lisa Moorhead. Rupert Ross.
Yes.
Raymond Williams.
Yes.
Madam Chair, I'd like to change my vote to yes.
Yes. Counted.
Madam Chair, 6 years, 5 nays, 1 abstain, 2 absent.
The amendment is passed. So we have a roll call on the original motion.
Lawrence Bashanti, absent. Lawrence Georges. Harry Daniel, absent. Wilma Mas Montando, abstain. Lydia Hendricks,
Abstain.
Alicia Wells,
Yes.
Arturo Watlington, no. Adelbert Bryan,
No.
Liliano Bellado de O'Neill,
No.
Roland Molina, Dan Webster,
The original motion, will you read that for me again?
the original motion is Senator Bryan's motion.
So, who's away here?
As amended, the original motion is as amended. Senator Bryan's motion, no, as amended.
No.
Okay. Lisa Harris Moorhead, Rupert Ross,
Yeah.
Raymond Williams, Madam Chair, 5 yeas, 5 nays, 2 abstain, 2 absent.
Motion, motion.
Madam Chair, I move that we adjourn.
Member Bryan has the motion.
Okay, yes.
There's a motion on the floor.
We already said Member Bryan has the motion.
Well,
There's no motion on the floor.
I know a motion that don't take precedent over any other motion.
Call the roll. Call the roll.
Take precedent. The motion
Motion to adjourn.
This was on the floor.
Call the roll for the
don't take
adjournment.
precedent.
He said a motion adjourned. Go ahead. Call the roll for adjournment.
Motion to adjourn.
Call the roll for adjournment. Say next
All
question.
right. Motion to adjourn. We're voting on that. Motion to adjourn. It's a roll call, excuse me.
Roll call is motion to adjourn. Lawrence Bashanti,
Vote accordingly.
Lawrence
We vote
Bashanti,
accordingly.
absent. Lawrence Georges,
No.
Harry Daniel, absent. Wilma Mas Monsanto, Lydia Hendricks,
No.
Alicia Wells,
No.
Arturo Watlington, yes. Adelbert Bryan,
No.
Liliana Bellado de O'Neill,
Of course not.
Roland Molina,
No.
Dan Webster,
I said no, but I said you say yes.
wait what it is.
No.
Lisa Harris, Moed, Rupert Ross,
Yes.
Raymond Williams, Madam Chair, 9 yeas, 3 yeas, 2 absent.
Motion.
Monsanto.
Member Bryan?
I move that we take a 45-minute lunch break. So move.
Second.
Objection.
45 minutes, is it?
Yes, ma'am.
Roll call.
Motion, I'd like to amend the motion. A motion in nature substitute to change the recess period to 20 minutes. So moved.
Objection. Roll call, motion has been seconded.
Roll call on the amendment.
No second.
No 1 second?
No
All right.
second.
Then a roll call on the original.
Motion to recess is
Oh, 45
minutes.
Last second.
I gotta write it down, but I'm sending it. Who seconded the motion? Who seconded the motion? Howard Bashalti, absent. Claudia Georges. Harry Daniel, absent. Wilma Marcos-Sandro. Lydia Hendricks. Yes. Alicia Wells. Drew Watkinson. No. Delbert Ryan.
Yes.
Liliano Claudia O'Neill. Roland Moina.
Yes.
Ben Webster.
Yes.
Lisa Harris Moorhead. Rupert Ross. Raymond Williams. Madam Chair, 7 yeas. 5 nays. 2 absent.
Well, you got somebody pick it up.
That is